I'm Riza Hussain, and today we're going to do a collab between the Digipod and Case in Point. We're going to talk about the Prevention of Electronic Crimes Act, due process, and recent cases. If we talk about the case registered against Iman Mazari and Hadi Ali Chattha, the case was registered by an NCCIA officer, and the contents of the FIR disclose that the primary basis for the FIR are certain posts on social media platforms, particularly X, that were made from Iman's account. And the FIR states that Iman posted content found to be offensive, intimidating, and false information against state institutions. But if you look at the contents of the tweets or the posts that are mentioned in those in the FIR, a lot of what has been said is stuff that has been said by politicians in the past. And as far as the enforced disappearances are concerned, as far as advocating against enforced disappearances is concerned, there are also judgments of the superior courts of Pakistan, including the High Court and the Supreme Court, on the role of the state when it does come to enforced disappearances. And in particular, there's a judgment and an order by Justice Athar Minilla from 2022 in a case of enforced disappearances, which is very instructive. And Justice Athar Minilla says that it is an undeniable fact that General retired Pervez Musharraf, who had taken over the reins of power after abrogating the constitution and thereafter had ruled the country as its chief executive for almost a decade, has candidly conceded in his autobiography, In the Line of Fire, that enforced disappearances was an undeclared policy of the state. The existence of the phenomenon of enforced disappearances is intolerable, and much more so when overwhelming evidence manifests that it has remained and continues to be an undeclared tacit policy of the state. So, some of the content which is included in those posts has also been affirmed by the superior courts of Pakistan. And when you look at the contents of the FIR, the offenses which have been invoked are Section 9, 10, 11, and 26A of the Prevention of Electronic Crimes Act. And these pertain to glorification of an offense, cyber terrorism, hate speech, and fake and false information. Now, why does this case matter? This case matters because in the present age, social media has become a powerful tool to voice one's opinion, to dissent, and to make oneself heard. And if you look at the content of the FIR, the allegation against Hadi is that he reposted, reshared some of Iman's content and some of Iman's posts, and therefore he glorified what she was saying. And when it comes to using social media, especially in the digital age, what this signifies is that not just posting content, but even reposting content or resharing content can make you liable for criminal proceedings and can expose you to criminal proceedings. And when the Prevention of Electronic Crimes Act was passed, at that time, a voice was raised that this is not legitimate reform and this is a law that will be used to curb dissent, to silence people that are speaking up, that are talking, and to shrink the freedom in digital spaces. And that's how we've seen this law being used. And now that it's applying even to reposting of content, that has the potential to further shrink online digital spaces. And to talk about this in more detail, I'm going to ask Fariha to explain the offenses that have been included in this FIR and also more generally how PECA has been used since it was first introduced in 2016.
Thanks, Radha. So, as you've already outlined, several offenses have been invoked in the FIR. Section 9, which is glorification of an offense, Section 10, cyber terrorism, Section 11, hate speech, which have been very contentious sections since the beginning, and these have been present since the 2016 version of the law. Even prior to the enactment of PECA in 2016, when it emerged in the form of a bill, there were a lot of reservations against these sections. And specifically, I recall that about Section 9, which at the time had combined glorification and also hate speech, it was compounded as one offense. They had also put in the word if somebody has been accused or convicted of a crime. Now, our issue then was that throughout our history, political history, whether it's peaceful resistance movements, politicians, political parties, at one point or the other, depending on their equation with the state, they have been prescribed or they have been incarcerated, or there have been fabricated cases. And any human rights advocacy has to do with the rights of the accused or even convicted when such things happen. And so, what we said at the time was that this is essentially criminalizing discourse or human rights advocacy that also happens on social media. And today, that is the only space available. And we've seen that some of the tweets that have been referenced in the FIR or the Challan in this particular case as well, mention those who are incarcerated. And there's human rights advocacy with respect to these individuals. Now, we also talk about how the state arbitrarily prescribes organizations or individuals, and this happens belatedly. The other thing is that 26A, false and fake information, is an offense that was inserted through the 2025 amendments. The tweets that have been referenced range from 2021 to 2025. So some of them predate this amendment and this particular offense, which pertains to false and fake information, which is also vague because there's no threshold to identify what. And it also borrows language from the Anti-Terrorism Act, which has also been copied in Section 10. So to create fear and panic in society, etc. And so can it be applied retrospectively to tweets prior to that? Are they going to bracket those in the other sections of the law? And also with these sections of the law, there has been a pattern. When political workers and journalists have been booked, 9, 10, 11, and 20 have featured consistently. And now, these days, instead of 20, we're seeing 26A feature in FIRs. And the thing is that a lot of times, many of these cases, when they're put to the test and when they go through the motions, belatedly, some of these have been quashed as well, right? Because the offense doesn't fit the language of the law. But irrespective, notices are issued, FIRs are registered, people are detained or arrested, and all of this proceeds irrespective. But it's even where the language of the law is specific, there are vague provisions, right? And that's how they applied. And by the time that the stage comes to argue whether that particular piece of content or speech fits the offense or not, so much has already happened, which is why we keep saying that the process is used to punish people before there's a determination of whether it even constituted an offense. And we've seen that this is how PECA has been applied over the years for speech online.
I think you're absolutely right. And I think, especially when it comes to cases like this, what it signals to every single Pakistani, what it signals to every single citizen of this country that has a social media account, that is on social media, and that is posting, is that your activity is being monitored by the state and you can be punished by the state for activity online. And simply even reposting content which the state finds objectionable can also expose you to criminal liability. And as we've talked about in the mainstream, there is already very little space when it comes to television to speak out. And social media became an avenue for people to speak against injustices, to advocate for human rights, and to document what was happening, and to speak out against what they perceived was wrong, and to hold the government to account. And that goes to the heart of any democracy. And when the government starts labeling dissent and criticism as terrorism, invoking cyber terrorism provisions, what they are trying to do is send a message, and they are trying to instill fear so that people self censor themselves and that people don't speak out, and out of fear of being subjected to punitive proceedings. And it is in that way sending that message out to every citizen of this country. And that is why, when these provisions are invoked against human rights defenders, against journalists, it should send an alarm to every single citizen that is using social media, that it could also happen to them. And that when you give the state such arbitrary power through these laws, then that's not just restricted to certain individuals, then it can be invoked against any person. And once that precedent is set that they can do it in one case, then there's nothing stopping them from doing it in several other cases as well, which is what we've seen them do. Use it against journalists, lawyers, human rights defenders, and the list will keep on going until the courts intervene, or until PECA, as we've been advocating for, is repealed and a law comes that is there with the intention to genuinely reform the online spaces. And when we talk about Iman and Hadi's case in particular, one of the most concerning and alarming parts of their cases has also been the fair trial and due process aspect of it, and whether those trials or whether those provisions in our constitution have been complied with or not. And in this regard, there has been an outcry from a vast section of society. When it comes to the bar associations, when it comes to Amnesty International, the International Commission of Jurists, you've had internationally, domestically, people raise their voices about the fact that these trials, or the manner in which they are being conducted, do not comply with fair trial and due process standards. But let's look at this in a bit more detail in terms of what is actually on the record and what has actually been reported in the press as well. So one of the first things that has been reported is that a state council was appointed for Iman and Hadi, despite the fact that both of them had retained private counsel, and there was information on the record showing that they had retained private counsel. And on one date of hearing, the state counsel that had been appointed came to the court and was expected to conduct the cross examination. And he told the court, he said that he had been given a list of 15 questions to ask the prosecution witnesses. And he went on to say in an interview that he could not ask dictated questions, and his conscience did not allow him to ask dictated questions. Now, instead of asking the lawyer who was dictating him or where this dictation was coming from, whether there was external interference in the trial, the court appointed another state counsel for Iman and Hadi, despite the fact that both of them said that they had no confidence in the state counsel. So, when we talk about the fair trial, at the heart of the fair trial is the right to be represented by counsel of your choice and to choose your own lawyer and not have a lawyer effectively imposed on you. And so when it comes to the fair trial, we saw that was one aspect. Then the second aspect, which has also been documented and recorded, is that the evidence of the prosecution witnesses was recorded in Iman and Hadi's absence, and this was also reported in the press. And we saw videos where scores of police officers were actually escorting Iman and Hadi outside of the courtroom. And they were the accused in the case. They had the right to be present while the witnesses were being cross examined. And instead, we saw that they were being escorted out of the courtroom by police officers. And again, the accused have the right, whether it's internationally under the International Covenant on Civil and Political Rights, to be present when the cross examination is being conducted, and effectively to not turn the trial into a sort of trial in absentia, where you're making the trial into a one sided affair between the prosecution and the court itself and completely excluding a meaningful defense. And when it comes to a meaningful defense, at the heart of the Code of Criminal Procedure in our country is also Section 342, which states that the accused will be given the right to respond to the prosecution evidence and to put their position forward. And again, it has been reported that Iman and Hadi were not even consulted before the defense lawyer gave the statement under Section 342 and gave that statement effectively without consulting either of them. And this erases, in my view, in some respects, a meaningful defense from the record when you apply for a statement that is meant to be there to give the accused the opportunity to put their position before the court, to make sure that it's heard in their voice, to respond to the evidence that the prosecution has brought against them. And then after that, to bring their own witnesses in their own defense to make their defense. And you completely exclude them from that process. And instead, the state appointed lawyer submitted those responses without asking them. So even the manner in which this trial has been conducted, it raises a lot of questions about the right to a fair trial, about due process, and also the message that we're sending to every citizen in Pakistan again, that if this is a manner in which a trial that is so heavily publicized is being conducted, what about those trials which don't get the kind of publicity that this trial is getting? What about the fair trial and due process in those trials where the media is not reporting on it as much as is being reported in this case? So it raises a broader question about the judiciary, the state of the judiciary, and whether mandatory procedures that are there in our constitution, that are there under Pakistan's international law obligations, are being complied with or not. And as I said before, it's not limited to one case. Because when you allow this to happen in one case, when you allow it to happen to individuals, whether you agree with what they're saying, whether you disagree with what they're saying, you're opening the door and you're opening the space for the state to do it in a whole host of other cases. And in those cases, you might actually agree with someone, and they might actually be someone that you support. So it's not even about whether you support those individuals, whether you support what they're saying. It's about their right to say it anyway. And that is when we talk about a democracy, when we talk about the rule of law, it's the right to hear what you even don't want to hear, what you fundamentally disagree with. And in our state, from its, as you mentioned, they criminalize speech, they pass laws criminalizing speech. And even when we talk about international standards, there's also talk about how speech shouldn't be criminalized, especially when it comes to defamation of individuals or institutions, that sort of speech should not be criminalized, and any remedies should be civil remedies. Fariha, if you can also tell us a little bit about the penalties under PICA, and especially the provisions that have been invoked that we've spoken about, whether it's cyber terrorism, glorification, hate speech, and also about the way forward. That, this, it's almost 10 years to PICA now. We've seen how it's been used, it's been amended various times, and each time it's been amended, the amendments have been even more draconian than what the law was, and haven't really improved it or taken any of stakeholder feedback. They've just made an oppressive law even more oppressive. So how do you look at the penalties? And in terms of 10 years of PICA, that is soon, it's going to be 10 years of PICA next year, how do you look at the law and what the state has managed to achieve through it in the last 10 years?
26A, when it was introduced as a cognizable offense, and it carries a punishment of up to 3 years and fine. The other sections have punishments up to 7 years, and then cyber terrorism up to 14 years. And these are very high punishments, as well as fines that run into the millions, right? And you could be sentenced separately for each one of these offenses. What you also said about whether something should be a criminal offense or not, and that has been an argument with PICA. Whether some of these offenses as they exist should even be in the law, which is why there have been a lot of, even initially when PICA was a bill, there were demands to omit certain sections completely from the law because it was excessively criminalizing speech, and vaguely so. For example, we've seen mostly the FIRs are also vague. They typically pertain to anti-state remarks or derogatory comments about the state or public institutions. And this is typically the language that is used. And we see this reflected here as well. And also the corroboration of whether something constitutes an offense under the law or not, and how do you connect somebody to the offense, right? All of these things, and also in terms of forensic evaluation. In this particular case, also, we saw there is no forensic available, and a technical report has been seized. Like, how do you seize a technical report? Typically, you would present that as evidence, right, or exhibit it, and it's very odd. And if this can happen to two human rights defenders, what happens to every other person who doesn't have that kind of visibility or the ability to get counsel? And even here, if you don't have counsel, right? And we have to also look at the cases that have emerged after these amendments, where they have impacted the average person. We saw that it was reported that somebody who criticized clerics for announcing the second day's moon for Ramzan was booked under PICA, or somebody who made a video of a traffic warden was booked under PICA as well. And these are consistently debates we've had over the years, right? Oftentimes we say that, well, at least nobody's getting convicted, although now with their case, it seems that, a conviction may be imminent. And so far, we've always said that the process is the punishment. But something that was, just registered a few months ago is now reaching sort of the trial is being concluded, and to what end. So those are the questions that also remain for others, how this is going to impact them. Every case has a ripple effect, not only just in terms of messaging, but the precedent that it will set. And while we see that a lot of cases, other kinds of cases also then make their way up to the High Court and Supreme Court, and we've seen that a lot of convictions get overturned at that level. But everything that has happened in that period where somebody has suffered, or even if somebody ultimately gets acquitted, whatever they're subjected to is harassment and coercion of a different nature, and a lot of rights in this process are also taken away from you. And so, what protections do you ultimately have on paper and in practice? And then there's this also looming question about now post 27th Amendment, how will the courts look at these cases? Anyway, we've seen that when it's about anti-state content, there's a particular approach. But how are even the higher courts going to respond to appeals? Let's say we do not know, or fair trial violations, as you've listed. And just before we conclude this conversation, Ridan, you've already mentioned this, but for the average person to also know that, one, this law applies to them, this, and especially the changes that have been made are even more draconian, right? Because earlier, what we were able to fight out in court with and get quashments is that a third party can't be a complainant. Let's say for Section 20 cases, that's what we used to say. Here, NCCIA officer, the case has been registered by the state through an NCCIA officer. And now, because the law has changed, that anybody can be a complainant. And the definition of person has changed from, a natural person to anyone who, it can be a body politic, a corporate, etc. So obviously the wide ranging definitions, but still, Article 10A, what are some of the things and the procedural requirements that people should be aware of if they receive a notice, if there's an FIR, and if something goes to trial, that they are entitled to? Because what we've also seen is, for instance, things like supply of copies and applications have had to be filed, right, to receive them, which seem to be fairly standard procedures. If you could just address that as well.
So, as I said before, Pakistan is also a signatory to various international conventions, and these international conventions are also linked to Pakistan's GSP plus status. So, Pakistan retaining its GSP plus status is in a way conditional upon Pakistan complying with 27 core conventions which are listed, and in those are the ICCPR. And Article 14 of the ICCPR goes into a lot of detail about what anybody accused of a criminal charge is entitled to. And the first thing that it lists is that you're entitled to a hearing before an independent, impartial court. You're entitled to be informed of the charges against you in writing. And what is crucial is that when you're being informed of the charges against you, they must be in a way that is in detail and that clearly communicates to you exactly what the charge against you is. So if we look at Iman and Hadi's case, or if we look at other cases which have been filed against journalists, the charges are so vague that at times it just says that comments against state institutions or rhetoric against state institutions, without really going into detail about A, what that content is, and B, if they have expressly said what the content is, they haven't explained how that violates the law or is in contravention of the law. It just sort of lists the content. So when you're communicating a charge, it is extremely important that it in detail sets out what the case is against you. It's not vague, and you're not left guessing what you've done or what the case you have to meet is. And so when a charge sheet is vague, that does not comply with fair trial and due process standards. And then the right to counsel of one's choice. And the fact that we're having to even list this out as a fair trial requirement in 2025 is extremely, I think, unfortunate, especially in our country where Article 10A was enshrined in the Constitution in the 18th Amendment in 2010, formally enshrined as part of our constitution. It was there before, but it was included in the constitution in Article 10A. And even still, we're having to say that the right to counsel of one's choice is a fundamental aspect of a fair trial. And if you're going to impose a counsel, whether a state counsel, on the accused, that is not a fair trial, because any accused has a right to present their case through whichever lawyer of their choosing. And when you deprive them of that right, you're depriving them of the right to present their defense in the way that they want. And we've seen that when you impose a lawyer, state appointed lawyer, then whether they have time to prepare a defense with you, obtain instructions from you, that all goes into jeopardy. So, the right to counsel of one's choice, the right to call witnesses in your defense. Again, the fact that we're having to list this is a very unfortunate. That the right to present witnesses is a fundamental aspect of a fair trial, that you can present a meaningful defense before the court, and that the court knows both perspectives there before them, and they can't just have the prosecution witnesses without then the defense being given the right to call witnesses in their defense to put their perspective forward. So when we talk about the fair trial, it is just about giving the accused the opportunity to prepare their defense timely, and you have to give them the time to prepare that defense and give them the time to present it before the court. Because when we talk about a criminal charge, it involves potentially a penalty that will deprive an individual of their liberty, and even the burden of proof is beyond reasonable doubt. And so the standards are far higher, the burden is far higher, and each procedural step matters because any procedural misstep could potentially mean that you would wrongfully deprive someone of their liberty. So, at times it's just perceived that it's just a box ticking exercise, and what's the point, if we miss one step or we skip one step. It's not a small thing, because any procedural misstep could lead to a potential wrongful conviction, and then put an individual, deprive them of their liberty without the proper process. So the process is extremely important, and it's not just the end result, it's how you get there, it's the manner in which you get there. And especially in cases such as these, when it comes to journalists, human rights defenders, we've seen how they've at times been conducted with unprecedented haste. At times, they are dragged out so that there's a sword hanging over the head of a journalist, for example, or a human rights defender, that they have this PECA case or another criminal case hanging over their head, that every time they're reporting, they know that, the state has this case against them, and they can sort of accelerate it at their desire, and sort of use it against them when they are reporting. So the manner in which we've seen the laws be misused, the ways in which we've seen fair trial guarantees be misused, it is extremely alarming for every one of us, as I said, that are in the digital space, that are using their voice, and that are, speaking out. And especially in a democracy, as I said before, this is our mechanism to hold the government to account, because there aren't very many ways in our country, in any case, to hold the government to account. And in the recent past, especially, one of the ways that has been used to hold the government account is social media, is to fact check the government on social media. Because, oftentimes the government is just using these laws against journalists and human rights defenders. What about when the government is fact checked? Why are these laws, used against the government? They're only used against those that are holding the government to account. So we've seen a regrettable pattern over the last few years, ever since this law has been used. And unless it is repealed, and I don't think that things will improve. And especially, Fariha, we talked about the judiciary as well, and you can talk about this as well. Post the 26th and the 27th Amendment, we've also seen a complete capture of the judiciary. And you have judges that are now in the Federal Constitutional Court that are sitting there by virtue of the fact that the executive has appointed them. The government has increased their role in judicial appointments and increased their role in the Federal Constitutional Court. And even at the High Court level, the government has increased their control over the courts. So previously, where you would have hope that if injustice is being done against me, I can approach the courts. Post the 26th and 27th Amendment, you can speak to the general citizens and people that are familiar with the legal system as well. The hope, even with the courts, has diminished significantly post these amendments. So it's not just speaker, it's about a total capture of the entire system, which then leaves you without any remedy. And again, that is very frightening for any citizen, that you're living in a state where there are laws which are open to misuse, and then you have courts which have been captured by the executive. And if you do get relief, it's an exception. If the courts get it right, it is perceived as an exception, and it's not the rule, because you're expecting injustice, and that's where they've brought our legal system.
And Rida, since you spoke about misuse, there was recently a case in Karachi of an ordinary citizen who had actually been arrested because somebody had created an impersonated profile and had published remarks about state institutions. And he was arrested as a result. And he then played in court a voice recording saying that actually there was a property dispute with his brother. And he had been threatened that if he didn't settle, then this would be done. And that's exactly what transpired. So, this is why every individual needs to care, because PECA applies to everybody. And any utterance, whether it's a fake or hacked profile or account, or it's actually your own and your own expression. What Rida also mentioned, that it is so vague. And 10 years on, we don't know any better what actually constitutes an offense or not. The lines keep shifting. An offense is anything that the authorities at the time wanted to be, which is why there is no clarity. And so you don't know for what utterance you're actually going to face a criminal trial. And that really is what the danger is. And now, with the courts in terms of seeking relief, the arbitrariness of it is so much that you don't know. And to these days, grant of bail or denial of remand is what serves as relief, which is unfortunate. And we've seen this in cases where, whether it's something that a guest has said on a podcast, as we've seen with Saurabh Barker's case, or a thumbnail and a caption that has been wrongly presented in court, which happened in Farhan Malik's case, or even previous cases where we saw that Bilal Faruqi was criticizing a band outfit, and yet he was the one who got charged with hate speech. Or there are scores of other cases of journalists and ordinary people who are being subjected. There's action against them under PECA. And this is something that is going to spread across society, where it is weaponized to settle personal scores and disputes as well. And where we speak about institutions, of course, in international jurisprudence, under the ICCPR, there's a higher threshold for public officials. And the protections that an ordinary citizen enjoys is not something that institutions or public officials can enjoy in the law, but they do now. And in fact, it's excessively criminalized speech when it's about them, when it's really about holding the state or the executive, particularly, to account. This is all that we have today in this collab between the Digipod and Case in Point. This is something that obviously we're speaking about specific cases and examples, but the PECA affects everybody. And you should know what your rights are, but also how they're compromised at this point when you try and seek remedy, and also what the law is and how it's misused. This is all we have today. Thank you.